The committee will come to order. Good morning. Today, the Small Business Committee will examine how small business owners have used intellectual property protections to help their businesses and the issues they face when navigating the intellectual property process. Intellectual property plays a vital role in protecting creative and innovative products and ideas. Our nation's small business owners are essential to producing new, creative, and groundbreaking products and ideas that strengthen our nation's economy. In fact, entrepreneurs and small business owners have generated more than 63% of the new jobs over the last 2 decades, and small businesses represent about 96% of employer firms and manufacturing industries with a high number of patents. Intellectual property protections also help small businesses grow. Studies have shown that small business owners can earn 32% more in revenue compared to their counterparts who have no intellectual property protections. Firms with intellectual property rights also pay, on average, 20% more in wages. However, the process for obtaining intellectual property protections can be daunting, even for the most experienced small business owner. Studies have shown that small business owners are not always aware that they should be protecting their innovative products and ideas through intellectual property protections, and those that are aware of their intellectual property rights do not always know how to navigate the process. It can also be very expensive to hire professionals to traverse the intellectual property process. As this committee knows all too well, most small business owners cannot afford to hire an army of experts to guide them through many processes, including the sometimes difficult process of obtaining these protections. This leaves them vulnerable to their innovations being stolen, both here in the United States and internationally. And if someone steals their ideas, it can be financially devastating for the small business owner. The FBI has found that intellectual property theft costs billions of dollars every year to America's businesses. And thieves are targeting small business owners and startups because of their limited abilities to fight back. To combat this problem, this committee unanimously passed H.R. 2655, the Small Business Innovation Protection Act of 2017, this past March. This bipartisan legislation would leverage existing resources at the SBA and the U.S. Patent and Trademark Office to better assist small business owners and expand the agency's outreach efforts to provide small businesses with the resources they need to address intellectual property issues. Today, we will hear from small business owners and their representatives who have been on the ground utilizing intellectual property protections. I look forward to hearing how intellectual property has helped their businesses and what we can do to foster America's creative small businesses moving forward. And I would now like to yield to the ranking member for her opening statement, Ms. Velasquez.
Thank you, Mr. Chairman. Many of our most successful ventures in America started as a note on a napkin, a schematic on a whiteboard, or a dream by an entrepreneur. When these ideas blossom into new products and services, they create jobs, a critical component of a healthy economy. The success of these new ventures requires a system that effectively protects entrepreneurs' ideas from being unfairly copied and stolen. Businesses that develop new products need assurances that the economic value of their innovations will be maintained. At the same time, we must ensure businesses know how to obtain those protections and enforce them. Doing so helps entrepreneurs reach global markets and the working capital they need to get off the ground. Because of our entrepreneurs' creativity, the United States is an unparalleled global leader when it comes to new ideas. In fact, nearly 45 million American jobs are supported directly or indirectly by industries with an intellectual property focus. This includes small firms that are independent television and movie producers, video game designers, songwriters, and manufacturers. Collectively, this trillion-dollar industry constitutes a significant aspect of our nation's economic success. Unfortunately, the full potential of this creative field has not been realized. Many more small firms could launch and contribute to this sector if they only knew how to protect their intellectual property. As the Internet continues evolving, the situation has become more complicated. While the Internet has empowered artists, retailers, and researchers to rapidly disseminate their ideas, services, and goods, it has also created opportunities for bad actors. For small, innovative firms, many of which already face challenges accessing capital, it is vital their investment be protected from counterfeits and piracy. Without such protections, these entrepreneurs will be unwilling to assume the risk necessary to produce the next market-disrupting invention, thereby hampering growth. This is especially true among women, minorities, and other underserved business owners who already face obstacles obtaining IP protections and funding. Not only do women-owned startups receive just 10% of all global venture dollars, they are awarded just 18% of U.S. patents. Addressing this disparity must be part of that conversation. Today's hearing will examine how the system for protecting intellectual property can foster innovation and parity among entrepreneurs. I thank our witnesses for being here. And Mr. Chairman, I would like to also acknowledge Mr. Schneider, who is the father of our colleague, Brad Schneider. Yeah. I yield back.
Thank you. The gentlelady yields back. And if committee members have an opening statement prepared, I'd ask that they be submitted for the record. And I'll take just a moment to explain our lighting system. It's pretty simple. You get 5 minutes to testify, and the green light will be on for 4 of those minutes. The yellow light will come on and let you know you got a minute to wrap up, and then the red light will come on, and we'd ask you to stay within that if at all possible. I would now like to introduce our distinguished panel here this morning. Our first witness is Nicole Rosen, who is General Counsel for EXPA. EXPA is a startup studio that helps entrepreneurs build and grow their business. EXPA has incubated 15 startup companies and advised and invested in 25 other companies across the country since 2014. Prior to her time at EXPA, Ms. Rosen was General Counsel at Kickstarter, a crowdfunding platform, and we welcome you this morning. Our next witness will be David Graham, who is the CEO of Code Ninjas, a franchise aimed to educate kids on computer coding. Mr. Graham has almost 20 years' experience as a professional software developer and entrepreneur and founded Code Ninjas in 2016. Code Ninjas began franchising in 2017, last year, and Mr. Graham is testifying today on behalf of the International Franchise Association, and we welcome you here as well. Our third witness will be Rick Carnes, who is the president of the Songwriters Guild of America, Incorporated, or SGA. SGA represents over 5,000 songwriters all across America. Based in Nashville, Tennessee, and a small business owner himself, Mr. Carnes has successfully co-written #1 songs for various country artists, and we welcome you here as well. And I would now like to yield to the ranking member for the purpose of introducing our fourth and final witness this morning.
Thank you, Mr. Chairman. It is my pleasure to introduce Dr. John Fallon, the founder and CEO of CureMark in Rye, New York. She filed her first patent application in 1999 and has worked to research autism and related disorders and bring them to commercialization. Before CureMark, Dr. Fallon worked as a pediatric chiropractor for 25 years, specializing in pediatric development. She has a BA from Franklin and Marshall College, a DC degree from Palmer University, and completed her work for MSc in clinical investigation from Harvard University's joint program with Massachusetts General Hospital. Welcome, and thank you for testifying with us today.
Thank you very much. And Ms. Rosen, you're recognized for 5 minutes.
Thank you. Chairman Shabbat, members of the committee, thank you for the opportunity to appear before you today. I hope to give you some insight today into the value that startups bring as today's small businesses and into the experiences that we have with the patent system and the intellectual property system.
Would you mind pulling the mic a little closer?
Yes.
Thank you.
So my name is Nicole Rosen. I'm General Counsel of EXPA. As the chairman explained, EXPA is a startup studio that helps the world's best entrepreneurs bring their ideas to life. We're a group of about 20 people. I'm in New York. A bunch of us are in California as well as in Vancouver. And we're bringing together founders, designers, and people with great ideas. and giving companies that are at their earliest stages the foundation, the resources, and the funding to turn their ideas into businesses. EXPA's incubated more than 30 startups from across the country. These include Current, which is a parent-controlled debit card that allows teens to build their financial skills. Spatial, which is a company that's building revolutionary virtual reality-based collaboration tools. And Shift, which helps veterans find careers that match their skills, values, and potential and connects those veterans to today's most promising companies. We're proud to be creating and supporting the businesses that'll drive tomorrow's economy. Now, startups and small businesses like these EXPA companies rely on the immense value that the patent system provides to entrepreneurs. It's a system that is meant to reward true innovation by allowing a patent holder to reap the benefits of her work while providing a service to the public in sharing her discoveries. Now, filing for patents is a long, arduous, and very expensive process. It's difficult and can be frustrating, but when the process works well, you're rewarded with a valuable asset, both for your business and for society. Now, reforms made by Congress, the Patent and Trademark Office, and the courts over the last few years have helped to increase the strength and integrity of the patent system, increasing the likelihood that the system does work well. Unfortunately, though, these reforms haven't been quite enough to prevent an insufficiently rigorous patent review process and subsequent abuse of the system. That's why for many startups and small businesses, the only interaction that they're ever going to have with the patent system will come through predatory patent litigation, the dreaded patent trolls. One of our companies recently went through this process when it was named alongside dozens of other companies as a defendant in a patent infringement suit. Instead of focusing on a big upcoming product launch, the team had to divert its attention to find a law firm and to fight the charge that they were violating a vague patent. Luckily, EXPA was able to draw upon some of its resources and help them get the complaint dismissed by showing that the company didn't even use the underlying technology that the plaintiff was alleging in the complaint. Unfortunately, we know that this is not going to be the last patent troll suit that EXPA companies are going to face. Now, before joining EXPA, I was at Kickstarter, and during my time there, we faced 5 patent troll suits directed both at us and at the creators and independent entrepreneurs that were using our site. Kickstarter was lucky enough to have the resources to fight these suits. EXPA's companies are at earlier stages of their business lives and don't have the same funds to stand up to patent trolls, but they at least can take advantage of a network that will help guide them through the terrifying world of patent litigation that opens up when you get that first demand letter. Most small businesses do not have access to these kinds of resources. They find themselves facing these threats alone, and they're forced to either pay a settlement or face years of very costly litigation. These situations have a major impact on businesses, leading to changes in strategy, diversion of resources, deferred hiring, and even complete shutdown in some cases. This is the reality that startups and small businesses face because of the proliferation of low-quality patents. When patents are unreasonably vague or incomprehensible, they allow the kind of predatory and extortionist behavior that I've been describing to you. Some recent developments have helped to improve patent quality. The PTO's post-grant review process that allows bad patents to be challenged after they've been granted, and the Supreme Court's Alice decision, which helped clarify that abstract ideas and processes can't be patented. But we still have a long way to go, and we are heartened by the attention that you and the rest of Congress are paying to this important topic. Now, today's small businesses may look different than those of yesterday. They're startups and technology companies that are in co-working spaces rather than storefronts. They're using the internet to reach not just their local communities, but a global audience. But startups still share so many of the same experiences, excitements, and struggles that small businesses have faced in every generation. There are few people putting everything they have into bringing an idea to life. They're balancing checkbooks, stretching dollars, and working around the clock to build their businesses. Whether that business starts as a small grocery store in Cincinnati and goes on to become the largest supermarket chain in the US, or starts by building computers in a garage in California and goes on to become the world's largest technology company, the potential of small businesses we know is vast. And as startups and technology-based companies make up an ever-growing part of the small business landscape, it is incumbent on all of us to protect true innovation and to allow these businesses to flourish free from the threat of predatory litigation. Thank you for your time, and I look forward to your questions.
Thank you very much. Mr. Graham, you're recognized for 5 minutes.
Thank you. Chairman Chow, the ranking member Velasquez, and members of the House Small Business Committee, thank you for this opportunity. My name is David Graham. I'm the CEO of Code Ninjas, the fastest growing and largest kids coding franchise in the United States. At our centers, kids learn to code using video game-based curriculum in a fun, safe, and inspiring learning environment. In March of 2017, we started franchising to expand our brand, and we have grown to more than 250 centers in more than 30 states. None of this would have been possible without the franchising business model and the IP protections it relies on. Small businesses actually constitute a large majority of franchisors and franchisees. The common denominator in franchising is that we rely on the small business model and use economy of scales to grow. In Code Ninjas' case, we use franchising to teach youth to use STEM education at an accelerated rate. Because franchisees are individual owners, ensuring brand protection is key to ensuring the customer's experience is consistent. The only way to give legal effect to brand consistency is through intellectual property protections. In other words, franchising should be understood as a system of licensing intellectual property where the franchisees are small businesses that hire, fire, and set the hours of their own people, but the brand controls the look and feel of that system so the customer experience is consistent. But because of the Lanham Act and its requirement that licensors police the use of intellectual property licensed to third parties, franchisors have the right and obligation to determine how their marks are used and to do so in a way that protects the consuming public. This means that we need a standardized set of training materials, branded uniforms, sales processes, and even jargon to use with the parents so that Code Ninjas isn't distilled into a simple curriculum that can be found online. In fact, one of our trademarks is the term kids have fun and parents see results, and this is the soul of our brand. This is to say that intellectual property protections are vital to the franchising model, but there are some areas IP law falls short. First, some states make franchise disclosure document registration relatively easy because they exempt franchisors if the brand has federally registered and approved trademarks. This could be done nationally and would save everyone time, effort, and money. Second, we have seen a number of companies apply for trademarks that would have confused our brand with theirs. The government should provide immediate feedback when someone attempts to register a mark so we can identify copycats. Third, we have seen international copycats who are essentially squatting on our brand. These squatters are able to game the system in part because there is no implicit protections for URLs that contain our US registered trademarks. Fourth, we need to strengthen our protections against misleading advertisements. One competitor used our trademark of Code Ninjas in their advertisement in an effort to funnel people into their own company. There aren't strong protections to help us remedy this IP infringement. And this is especially true for social media platforms where there is zero protection. Finally, we need clarity on the confusing joint employer standards. For example, I'm concerned if I provide certain training materials to my franchisees, which are important materials for brand consistency and that add real value to their small businesses, that those provisions and those materials could be construed as creating a joint employer relationship. I hope that Congress will continue to call for clarity on this in this area. Thank you for your time and for hearing my perspective on these important IP protections, and I look forward to your questions.
Thank you very much. Mr. Carnes, you're recognized for 5 minutes.
Thank you. The Songwriters Guild of America thanks the committee for this opportunity to testify on the importance of strong copyright laws to small business, specifically the small business of creating musical works. Our copyrights are our only product. We don't sell T-shirts or concert tickets. We just sit in a room all day slumped over a guitar trying to create magic on a blank page. And sometimes we have a good day. And on those days, we write a song that perhaps puts our kids through college or buys a new pickup truck or a refrigerator. And by the way, my name is Rick Carnes. I'm president of the Songwriters Guild of America, the nation's oldest and largest songwriting organization run exclusively by and for songwriters. I've been fortunate enough to have had a long, long career and have had #1 songs recorded by Garth Brooks and Reba McEntire and hits by Alabama and Steve Wariner and even, I'm proud to say, Dean Martin. among others. Yet, despite my success and good fortune, I'm reminded every time I see unauthorized copies of my songs posted online just how perilous the profession of songwriting is in the digital music age. The copyright protection enshrined in the Constitution has allowed the U.S. to become the world's commercial and artistic leader in the creative industries. But every generation or so, the government has to address whether or not those protections are still actually working. Like back in the 19th century when British and Irish sheet music was brought into the U.S. Without copyright, it made American songwriters have to compete with royalty-free songs from abroad. During this period, the U.S. lost its greatest pop songwriter of the century, Mr. Stephen Foster, who died in poverty in the Bowery in New York City with only 38 cents and 2 song titles in his pocket. As a result of such tragic cultural losses, the U.S. now respects foreign copyrights, and our copyrights are valid in other countries. There was a problem, Congress fixed it, and we all prospered thereby. Let's let that lesson not be forgotten. The digital age has brought new challenges and exposed serious flaws in what has today become an antiquated copyright system that is no longer protecting our songs online and thus isn't allowing us to achieve fair remuneration for our works, since we are forced to compete with pirated copies of our own songs. What other small business has to price its goods based on competing with outright theft? The government could certainly help in protecting songwriters with the elimination of unnecessary safe harbors for wealthy digital music distributors, the sunsetting of 75-year-old consent decrees on our performance right organizations, and finally, enforcing anti-piracy laws. But in the meantime, our best hope is self-help. The SGA supports the development of content delivery networks that give consumers better and safer access to music online at fair rates of remuneration for creators, and SGA is pleased to see that the Music Modernization Act is addressing some of these issues and was recently passed in a unanimous vote in the House. But there are other practical legislative fixes that songwriters as small business people need immediately. The single greatest issue of importance to the songwriting community, which remains fully unaddressed in the Copyright Act, is that in order to enforce our rights against infringers, songwriters literally need to make a federal case out of it, at an average cost of nearly $350,000 per federal suit. Since precious few songs ever earn that much money, songwriters are left with a right but no remedy. Strangely, if my neighbor borrows my $60 lawnmower and wrecks it, I can take him to small claims court and Judge Judy will make him pay for it. But if that same neighbor takes my entire life's work and posts it online for free, he can just thumb his nose at me and laugh, reposting it as many times as I can ask the infringer's network to have it taken down. Towards correcting that, the SGA has worked with the Copyright Office and the Congress to craft the bipartisan Copyright Alternative in Small Claims Enforcement Act of 2017 to establish a small claims venue in which to address such copyright infringement problems in a way that would make copyright more accountable, responsive, and efficient. Individuals would benefit from the small claims process as it would allow them to resolve copyright issues in an economically feasible way, which would be attractive to both plaintiffs and defendants. It is for these reasons that the SGA respectfully requests that the House Small Business Committee consider co-sponsoring the CASE Act. Long overdue legislation that would provide small business owners who devote their lives to creating value in copyrighted works with a remedy to protect those works. Once again, I want to thank the committee for giving us this opportunity to discuss the way that copyright helps to foster the small business community of songwriters. I look forward to answering your questions. Thank you.
Thank you very much. Ms. Fallon, you're recognized for 5 minutes.
Good morning. I want to thank you, Chairman Chabot, Ranking Member Velasquez, and members of the committee for this opportunity to speak with you today about the juxtaposition of intellectual property and small and startup businesses. One of the hallmarks of small and startup businesses is that they often have aspirations to be larger ones, with economic and social impact that are the backbone of job creation, economic independence, and prosperity. Great ideas are ones that solve problems. Protecting those ideas so they can mature for the benefit of others is key when we consider the growth and scalability of small business. The protection of ideas, designs, and innovation takes many forms, including patents, trademarks, and copyrights. The existence of patents and intellectual property was a vision held by our forefathers, and they created those rights under our Constitution. I am the founder and CEO of a biopharma company called Curemark, located in Rye, New York. Curemark is currently working on an enzyme replacement drug for autism. The company was founded in 2007, but I personally have been working on the science since 1998. As a company, we've conducted 2 FDA Phase 3 clinical trials at 33 sites across the U.S. We plan to meet with FDA later this year to discuss our findings and to file a new drug application. Curemark, like almost all other startups, has transitioned through a process of discovery, validation, and scale. We would not exist as a company today if it were not for our intellectual property protection. Our IP has allowed us to protect our findings, raise money, demonstrate efficacy, and put forth the novel science which hopefully will benefit millions of American children. Curemark, since inception, recognized not only the need to patent its discoveries, but to develop and execute on a well-rounded IP strategy. The extraordinary length of time pharmaceuticals require to develop, become validated through benchtop testing and human clinical trials, obtain regulatory approvals, and bring a drug to market requires the creation of an environment for relentless discovery and innovation. The issuance of a patent, in my opinion, is one of the most egalitarian processes that exists in our country. Patents are granted without regard for race, age, gender, socioeconomics, education, geography, or even living status, because yes, even a deceased person can be granted a patent if their heirs apply for one. In the early days of our republic, women did not share in equal rights with men to own property, to vote, or to have a separate economy. Despite this, they could still be granted a patent, thus rewarding their innovation and creativity equally, despite their inability to benefit from it financially. Today, there remains a significant dearth of women patent holders. Recent statistics from the Institute for Women's Policy Research shows that 18.8% of all patents list at least one woman, but only 7.7% of all patents list a woman as a primary inventor. The National Bureau of Economic Research makes the case that if the patenting gap were closed just between women and men, it will result in an increased GDP of 2.7%. Further, the research shows that there's a socioeconomic patenting disparity as well, where children in the top 1% of income distributions are 10 times more likely to be inventors than children with below median income parents. We also know that children exposed to innovation are more likely to be inventors, and where they live influences that exposure. 80% of the patent holders live in the 100 largest metro areas in this country. The need for innovation and intellectual property, however, exists in rural and manufacturing communities as well. A U.S. Chamber of Commerce report found that IP-intensive industries, workers make on average higher wages. Additionally, IP drives each state's manufacturing exports, leads to increased R&D investment, and stimulates and protects innovation. We also know that companies who have intellectual property are more likely to receive venture capital. In conclusion, I'd like to state that the intellectual property belongs to all Americans. Innovation is a foundational principle of our great nation, and I believe that the federal government is key in fostering innovation. I propose that we set up federal offices of innovation in every state, thus making the patent process accessible to everyone. We need to encourage and teach innovation and design thinking in our schools so that young people nationwide, regardless of whether they have an idea for a new blockchain technology, a new method for growing corn, or for a car that runs on water, have the opportunity to realize these ideas. The USPTO, the SBA, and the U.S. Congress form a powerful platform, and together we can change the face of our nation through our innovation. Thank you again for giving me the opportunity to speak with you this morning. I look forward to your questions.
Thank you very much, and I'll begin with myself, recognize myself for 5 minutes, and I'll begin with you, Ms. Rosen, if I can. What advice would you have for startups or other small business owners when it comes to intellectual property protections? What do you think they ought to be looking out for? What experiences have you had that you could give folks
Sure.
out there?
Thank you, Chairman. So yeah, I think with my experience at Kickstarter and at EXPA, I have a lot of experience working with people at the earliest stages of their businesses. At Kickstarter, it was creators and entrepreneurs who were putting their projects on the site, and at EXPA, as I mentioned, were the earliest startups. And the thing that I would recommend most is to start thinking about these things early and to draw upon all of the resources that their community and that the government provides. Why I'm so heartened that we're having this hearing today is to know that the government is paying attention to this and exploring ways that they can provide additional resources to the smallest businesses, the people who don't already know how to take advantage of the protections that the Patent Office and others provide for them. So I would tell them to think about patents, trademarks, and copyright protections as a core asset of their business, to consider at the same level as their product, and to think about how they can really take advantage of the existing resources as well as push for additional ones so that they can build their businesses on the value of their intellectual property.
Mr. Graham, could you describe the process that you went through as a small business owner to obtain a trademark for Code Ninjas? Where did you start? What resources did you use as you went through the process?
Sure. First of all, we had counsel already set up for our franchising, and they counseled us to go ahead and start the trademark process as early as possible. As I mentioned earlier, we had, in certain states, you can go through the registration process for your FTD a lot easier if you have a registered trademark nationally. So it's a bit of a chicken or egg problem, because to get a trademark you have to be in business, but we needed one to be in business. So it was a bit of a contest to see which came first for us. That said, you know, there wasn't a lot of resources. I would agree with her that there weren't a lot of resources as a small business person to get in front of this problem without going to a lawyer and basically having them settle it up for us.
Okay, thank you. Mr. Carnes, I'll go to you. Could you walk us through the process of obtaining copyright protection, you know, in your industry, the songwriting industry? How long does it take? How much does it typically cost, and that sort of thing?
It's changed a lot recently, because in the past we basically had music publishers that took care of all the paperwork for us, and we just spent time in a room writing. But now, since the internet has sort of decimated the middle class of songwriters, most songwriters are self-published, and so we have to do a lot of that paperwork ourselves. So you have to register the song at the Copyright Office. You've got to register it with the performing rights organizations, you know, issue mechanical licenses. It's a pain. I mean, there's a lot of different rights in copyright, so it's become very complicated now.
Okay, thank you very much. And Ms. Fallon, I probably got just enough time for you. We had a hearing here just last week, actually, on people who have some sort of developmental disability, and two of the main ones that we were dealing with were autism and Down syndrome. And some were as an employee, some were as entrepreneurs themselves, and in some instances, one in particular, you know, the father was very involved in his son who had Down syndrome, and had a very successful sock company. And so I'm just interested in you mentioned autism and the drug that you're working on. In fact, my chief of staff, her daughter has autism, and something that they work on, and she informs me about the struggles that they have to go through. So how is the autism drug that you were talking about, where are you at in that, and how do the prospects look?
Thank you for that. Our drug is an enzyme replacement. So what we found, or I found early on, was that there's a large group of children with autism on the spectrum who are missing a particular enzyme that digests protein. And the children have very self-selected diets that they don't usually eat protein. And so the physiology of it is that it breaks down protein and frees up amino acids that are used to make neurotransmitters. And that's sort of a very succinct way of describing that. But supplementing the children has been done now for almost 10 years, and we have ongoing trials, open label trials.
Thank you.
Thank you.
I'm not sure what you just said, but I'm going to tell my chief of staff about it. So my time has expired, and I'll now, the ranking member, Ms. Velasquez, has 5 minutes.
Thank you, Mr. Chairman. Dr. Fallon, in our meeting last year, you got me thinking about equity within the patent system. And that is one of the reasons I introduced H.R. 3517, the Women Inventor Development and Equity Act. Dr. Fallon, we all know that women already face challenges accessing venture capital at a higher rate than men. So how can not holding a patent further compound this existing barrier?
Thank you, Congressman Velasquez. I believe that the holding a patent actually is a sort of third-party verification of the fact that you have a novel idea or a novel discovery. And I think that is something that you can actually hold out to investors. It's one thing for you to talk about it. It's another thing to show that the USPTO believed that this was novel.
Thank you. And do you support legislation that will require the federal government, specifically USPTO, to collect data on gender, race, and income gaps in patenting and their impact on small business and entrepreneurship?
I believe if we don't know the extent of the gap, then we're going to have problems fixing it. So yes, I do support that.
Mr. Carnes and Mr. Graham, piracy continues to constrain your industries. Can you discuss how your industry is addressing this problem on its own and what Congress can do to alleviate the problem?
Yes, we have always advocated for safe and easily accessible alternatives to piracy, because so many times the excuse for piracy is, well, we couldn't find this song online that we could pay for, so we just stole it. And it's taken, almost 2 decades to get those businesses built and up and running because those businesses are competing against free. So it would have really helped to have more enforcement on the government side to make those businesses more profitable. So that would be, the way that we mostly handle them.
Thank you. Mr. Graham.
Piracy, as it's concerned with franchising in our small business specifically, would be related to around what I call squatters making attempts at our URLs internationally. So codeninjas.eu, for example, is held by somebody that registered after our trademark went through, and yet when we go into the EU, we will have to pay them some, basically a ransom in order to get our own domain back, where we should have had a mechanism built within the government or within the ICANN or some other entity to go ahead and register those internationally, so that when we, especially ones that are geographically based, like the EUs and the .co.uk's and that kind of thing, we should be able to get our own domains.
Thank you. Ms. Rosen, you mentioned slow processing times and high costs for patents. Can Congress or the USPTO do anything to ensure small firms are not hindered by this process or costs? And are there any models in other countries that we can look up to?
Yeah, thank you for the question, Ranking Member Velasquez. I think that the best thing that this committee and Congress can do is work on the educational resources that are available to small businesses and really direct it to the specific needs of small businesses and startups. And, hiring lawyers is always going to be expensive. We want the patent system to be rigorous. We want to make sure that the patents that get through are high quality. So that is going to take time and therefore money. But there is a lot of room for the Small Business Committee to represent the interests of startups and small businesses and to work together with the Patent Office to make educational resources available. I don't currently have any other foreign models available, but I'll look into that and get back to you.
Thank you, Mr. Chairman. I yield back.
Thank you. The gentlelady yields back. The gentleman from Missouri, Mr. Lukemeyer, who's the vice chairman of this committee, is recognized for 5 minutes.
Thank you, Mr. Chairman. Interesting discussion today. Thank all of you for being here. It's a little frustrating, I know, as a small business person, to have your heart and soul poured into whatever product or song or research you've done, and they see somebody run off with it and beat you to the punch to the marketplace. It's we need to make sure we find a way to protect those folks from that. Ms. Fallon, you made a comment a while ago that you even patent the discoveries. So in other words, just make sure I understand what you're saying here, that you've patented the process by which you were able to discover the enzyme that was the problem. But then I guess, would you patent then also the drug or the cure for this situation? Is that what you do?
Yes, thank you, Congressman. Yes, absolutely. In addition to the makeup of the drug and how it's manufactured. So there are multiple places where we have patents around this.
So the fact that you patent a discovery process or whatever it was, how you found this, would protect your ability then to figure out how to find a cure for it. Is that why you patent that? Is that how that works?
Yes, it was the relationship between the low level of an enzyme that's missing and then the replacement of it and the results of that.
Okay. Mr. Carnes, I kind of figure out that you pretty well know when somebody's infringing on your patents, because you hear the tune somewhere or somebody will he give you a heads up on it. But I know Mr. Graham and Ms. Rosen here. How do you find some of these other folks that are infringing on your patent in a timely enough fashion that you can get out in front of it before these folks destroy your product or your service, whatever it may be?
Yeah, so that's a very proactive outreach that, using the USPTO website, using different resources, and we hire a firm actually to protect our assets in that
Well,
way.
that was going to be my question. You almost have to have somebody who sits there and
Yes.
trolls actually the whatever goes
That's
on
exactly
out there in the
right.
world in your industry to be able to protect it, none?
That's exactly right. And if I could make another request, get one of her guys to go ahead and build a better user experience on that USPTO website. That would be great. But one of those features that I think would be good is if we could put in like a Code Ninjas, the term, and then if either Code or Ninjas or in my example, ever gets registered again, I just get a simple email. I mean, that would be a very easy system to put into place, and it would notify us reactively instead of us having to go proactive approach.
Mr. Carnes, I think you mentioned it costs about $350,000 to defend yourself on an average suit. Is that what you just said?
Yes. We have to make a federal case out of every infringement suit.
How does that affect the ability to protect your patents, or your copyrights? I'm sorry, your copyrights.
It virtually makes it impossible.
The average songwriter can't afford to do that, can he?
Not at all.
Do you find a sugar daddy somewhere, or do you find a
No,
music
actually-
distributor somewhere that wants your song and wants to protect it? Is that how
Well,
you do that?
if you have a major publisher, like, a record label publisher or something, and they look at the infringement and they deem it so egregious that it's worth spending the $350,000 to go after it, they would have the resources to do that. But I point out that in the last 20 years, as far as I know, the only, big piracy infringement suits were like launched by the RIAA, and neither one of them really netted any return. I mean, they proved that there was piracy, but there was no money there to recoup the $2 million in one case that the suit cost.
Oh my gosh, Ms. Rosen, how do your entrepreneurs, your incubator folks here, how do they afford to fight this? I know, or what's your average cost, I guess I should say?
Sure. I think actually for most of our companies, they're too early stage to even get to the point where they're fighting this, but they're working on building their trademark portfolio, for example, and their patent portfolio as they build their businesses. And as Mr. Graham said, a service provided by the PTO that monitors new registrations and allows you to be aware when there are new trademark registrations that might possibly infringe on yours would certainly be helpful. I would actually argue that in the patent context, it is not the threat of infringement that's the biggest issue for small businesses. It is people who actually weaponize their patents and seek infringement anywhere they can, or a potential argument for infringement, and those are the sort of patent trolls that I was describing.
I want to get one more question
Sure.
real quickly here. You made a comment a while ago with regards to needing more resources.
Mm-hmm.
What do you mean when you say that they need more resources? Define resources for me?
Sure. So what I was describing is really educational resources. Let me back up and say that really across the board would need more money, more affordable lawyers, more education. But if we're talking specifically about what the government can provide, that will be education and outreach and guidance specifically aimed at small businesses and startups for filing patents, for filing for trademarks, for working through that process.
And
And
you're talking about maybe a how-to manual whenever you apply for a patent, how to do this all?
whether that's a how-to manual or specific people within the PTO who are there as people that small businesses can reach out to as kind of guides through that system, I think there are a lot of opportunities there.
I thank the chairman for indulging me.
Sure. Thank you. Gentleman's time's expired. The gentlelady from North Carolina, Ms. Adams, who's the ranking member of the Subcommittee on Investigations, Oversight, and Regulations, recognized for 5 minutes.
Thank you, Mr. Chairman, and I want to thank you and the ranking member for holding this meeting, and thank you for your testimony. It's a very interesting topic. It's certainly one of concern to me. I am a visual artist, and I have just seen over the years works actually being hijacked in various ways, especially with the internet now and folks putting their work out there. So I just wanted to say that, and I appreciate your interest and what you're doing with your businesses. My first question is for Ms. Fallon. As a first step to address the gender and race gap in patenting, would it be helpful for the Small Business Administration to examine the gender, race, and income gaps in patenting and their impact on small businesses, business and entrepreneurship?
Yes, I believe absolutely. I think that to solve a problem, you need to understand what it is and to look underneath the hood, as it were, to understand that gap, where it exists, and also why it exists.
Thank you. According to the Institute for Women's Policy Research, even among college graduates, African Americans and Hispanic Americans hold nearly half as many patents as whites, about 1% each. African Americans and Hispanic Americans also apply for patents at nearly half the rate of whites. Professor Cook at Michigan State has also estimated that including more women and African Americans in the innovation pipeline would increase U.S. GDP anywhere from 0.65 to 3%. Are we wasting economic potential by letting gender, income, and race determine which of our children will participate in the innovation pipeline? And what steps should Congress take to help narrow the gaps? And this question is for anyone on the panel who'd like to speak to it.
Sure, thank you, Congresswoman Adams. I think you're absolutely right, and this needs to be a collective effort from all industries and government. I think that the pipeline issue, as with so many questions of diversity and inclusion, is at the core of what the problem is. If we don't have people who are being educated in STEM fields, if we don't have people of color and women who are adequately represented among startups, we're not going to have an equal representation within the patent system either. And so I would love to see more industries working together. I'm very heartened by the fact that the tech industry is one where there has been enormous attention to diversity and inclusion, and rightfully so. And I would love to see that done more broadly, and realize that it's truly systemic.
Thank you. Ms. Graham?
Yeah, so the tech industry has changed over my career. Obviously, the nerds had it going pretty good there for a minute, and then the word got out. It was a pretty good job. So everybody's getting on board with being a computer programmer or in some kind of STEM, and we love that, to be honest with you. This has been a fascinating journey because, over 60% of our franchisees are women or minorities. So we're proud of the fact that we were able to bring a tech-based education system to help more people get in there and fill that pipeline. We're teaching kids, for jobs, or 2035, 70% of the jobs that will exist then don't even exist today. So automation, all kinds of different things are coming, and we're preparing kids of all backgrounds for that next generation.
You focusing on women in particular?
We don't have a specific focus, but they're certainly very involved with what we're doing. They come from the education background typically, so we're kind of bridging two worlds, technology and education.
Okay.
So,
Yes, sir.
Growing up in Memphis in the 1960s, I can certainly tell you how much including African Americans in the copyright community can boost the local economy. Not just local, but national too. As a visual artist, I would like to remind the committee that the CASE Act would certainly help photographers. My daughter's a professional animator. I mean, that's one thing that would really help if the committee would co-sponsor the CASE Act.
All right, well, I certainly support it. Did you want to comment? We got 22
Yes,
seconds.
talent exists in every corner of this country. And I think finding that talent, encouraging that talent, and encouraging that innovation is really our job. And so I absolutely support looking for that talent and innovation.
Great, thank you. Mr. Chairman, let me yield back.
Thank you very much. Gentlelady yields back. The gentleman from Iowa, Mr. Blum, who's the chairman of the Subcommittee on Agriculture, Energy, and Trade, is recognized for 5 minutes.
Thank you, Chairman Shabbat. Thank you to our panelists for being here today. And I'd like to compliment my colleague, Ms. Adams, on her wonderful hat today. Very nice, very nice. Mr. Graham, I wrote down here, you mentioned a better user interface with government software. That's kind of an oxymoron, you know. We had an executive from Silicon Valley here in Washington a year ago talking about IT in the federal government, and his quote was, "I felt like I went back in time."
I agree with his sentiment. Yes.
I have a question, Ms. Rosen, for you. You mentioned in your testimony, I believe, patent trolls.
Yes.
I own part owner of a software company. I've been in software, small, some bigger, some went public over the last 20, 25 years.
That's great.
To me, it's almost like legalized extortion in that you can get a letter, and our company has, get a letter and say, you know, you're violating this innocuous patent we've never heard of because I'll use an extreme to make an example, because you use the word "the" on your opening page of your software. Cease and desist immediately, or pay us money. Now, to me, it's almost like a big business versus a small business thing. And we all know that the complex favors the large. So big companies don't have a problems with excessive regulations. And big companies can do these types of things to small companies because we don't have a bevy of attorneys and lawyers that can fight for us. And it's a very frightening thing, and it can bring some small businesses to their knees. Absolutely. Can you comment, please, on patent trolls?
Yeah, thank you, Congressman. As you mentioned, this is an enormous issue for the smallest businesses, and it really is those businesses that find themselves crippled by these demand letters that they receive. And what's happened is that up till 2011, and the American Invents Act was passed in 2011 and really helped the situation progress, and we've seen patent trolls fall to a certain extent since then. But like I said, there's still a ways to go, and we'd like to see more reforms. But
what do we need to do specifically?
You know what I would
Congress.
like? Sure. What I would like is to protect the innovations that have passed. So these, protect Section 101 and the Supreme Court decisions that I mentioned, like Alice, that clarify that abstract ideas can't be patented. So at Kickstarter, we were sued by someone who had a patent for essentially crowdfunding for music. And this is an abstract idea, and we went through a 4 or 5 year court battle, spent millions of dollars, and eventually got that patent invalidated based largely on that Supreme Court decision, which said that this is just an abstract idea that you added a computer process to, that can't be patented. So it's really important to protect.
How much money, I'm sorry to interrupt, how much money was spent on that effort,
it
approximately?
Was about $4 million. Yeah. So,
Go ahead.
Sure. And like I said, Kickstarter was lucky enough to be able to afford that. Very, very few businesses are that lucky, and sometimes shut down simply because they can't afford to pay the settlement fees, the sort of extortionist fees that are charged. So these are usually people who are taking the patent system and weaponizing it.
Exactly.
Patents are a tool to build a business, to protect ideas that you are developing in the course of building a business, and to help you build something larger than that. What we're seeing with patent trolls is that they are using the patent system to secure an idea solely to monetize that idea. right? And usually those
It
are
reminds me
ideas.
of someone buying a drug that there's only one available in the country and then raising the price 100-fold. It kind of
is
reminds me of that
similar
very
to
thing.
that.
Would you agree?
Absolutely, absolutely. I think it is abuse of a system that is really at its core trying to accomplish something good for society and for small businesses and entrepreneurs everywhere. But we see that, like every system, it is prone to abuse. And I'm heartened by Congress and the government generally taking steps to protect against that kind of abuse.
It's an issue, it's an issue, especially in high tech.
Thank you, Congressman.
Anyone else, quickly, briefly, want to comment on patent trolls? Ms. Fallon, you're grinning. So, or you just want to tell a good joke?
I haven't seen one yet, but I thank goodness. But I also want to comment on your comment on the hat, because the first patent for a woman that was issued to a woman was for a hat.
For a hat?
Yes.
Excellent. Well, thank you for adding that on. Mr. Chairman, I yield back the time I do not have.
Thank you very much. You probably knew that anyway, didn't you, Mr. Baum?
Yeah, I knew that.
Okay. Thank you very much. See, we learn all kinds of new things in this committee. The gentleman from Pennsylvania, Mr. Evans, who is the ranking member of the Subcommittee on Economic Growth, Tax, and Capital Access, recognized for 5 minutes.
Thank you, Mr. Chairman. Good afternoon. Ms. Rosen, you mentioned resources, and I have a bill, House Bill 26, or House Resolution 2655, that talks about leveraging Small Business Administration resources in partnership in terms of this relationship. Can you speak a little bit to this particular bill?
Yeah, of course. Thank you, Congressman. I think that this bill is exactly the type of thing that we want to see. Collaboration across the different parts of government to make sure that different voices are heard, so that whether you're working with the Patent and Trademark Office and making sure that fees for the post-grant review process are lower for small businesses than they are for the biggest businesses, for example, or making sure that the voices of small businesses are represented where these conversations happen in the executive branch, in other parts of the legislative branch, in the Judiciary Committee. So I think that the Small Business Innovation Act is an example of the system working and ensuring that voices are heard across the board. So I thank you for your work on that, and I would love to see that passed and more bills like that. Thank you.
Thank you very much. Mr. Graham, could you discuss the franchise disclosure document proceed, why this continues to be a roadblock for franchises in some state?
Yes. So whenever you go into franchising, you have a federal disclosure document. This isn't a contract. This is just a disclosure saying, here's the state of our business and here's how things are going to go, generally speaking. Here's the nature of the relationships of our different companies and how they work together. And if you have any history, what's the history or the performance of franchisees in the past, so that they get a full picture of the nature of your company and what you're about and what they're about to buy into. There's most of these people are spending a large portion of their money that they've ever earned. So it's important. It's an important document, and we don't think that document needs to go away. We just need to make sure that all the states consistently allow us to register across those states. So, for example, in Illinois or California or a few others, it's very difficult for us to get that registration without putting up unnecessary bonds so I could see restrict other franchises from being able to operate in that state.
Thank you. I want to go back to Ms. Rosen. Basically, the BIO organization, led by a former colleague of mine, the Pennsylvania colleague Jim Greenwood, written a letter of support and consistent support innovation in America. And I'm reviewing the strong Patent Act, and though I have not co-sponsored, I believe that it's critical that we continue to work to make our system intellectual property stronger and more efficiently. And today, in one of our witnesses, I should say Ms. Falk talked in a testimony about the fairness of the patent system. Can you speak to that, about the fairness of the system?
Yes, I can only speak from my own experience, but I believe that it has been an enormously fair and egalitarian system. and that novel works can get a patent, and that we have the opportunity to present that novel piece and have it validated by the USPTO. So I feel very strongly about the fact that it's egalitarian and that everyone should avail themselves of it if they need to be.
Thank you, Mr. Chairman. You're back to balancing my time.
Thank you very much. And the chair would note the legislation that the gentleman mentioned, 2655, that Ms. Rosen indicated is good legislation, was introduced by Mr. Evans, and one of the principal sponsors on this side was Mr. Fitzpatrick, both gentlemen from Pennsylvania, and it shows again the bipartisanship of this committee, and I'd like to commend both gentlemen for their work on this, and passed this committee unanimously, actually, and we're working with the Judiciary Committee because there are some judiciary issues in it to try to get it to the floor and get it passed into law. So thank you for that. And Chair would now recognize the gentleman from South Carolina, Mr. Norman, for 5 minutes.
Thank you, Mr. Chairman. Thank all of you for taking the time to come. You know, we all get back to the fact that, as you say, Ms. Rosen, it's been weaponized. To be able to afford the legal cost alone for small business is almost impossible. I'm a small business owner, and it's a serious issue. And as I go around my district, going into different companies, it's a growing problem that's not going to go away. Mr. Carnes, in your world, walk me through to get a copyright, timing, dollars that it typically costs, and the steps that you would take in your world.
Okay. Well, in terms of cost, it's I think it's like $60 or something to register one song at the Copyright Office. But you can do several songs at once. You can make it like 12 songs, and you can keep the fees down. So it's not that expensive. It's kind of time consuming, and the process is, after writing all day, you don't want to come home and then spend your time copywriting things. And I've written thousands of songs, literally, and only a handful of them really make any money. So you have a tendency not to copyright everything until you see that it's going to be recorded, and sometimes that can be a problem. So the system works pretty well. I mean, it could be streamlined some.
And what position does a songwriter have who just doesn't have any copyright protections? Is it really, as you say?
Well, publication is supposedly a copyright. Like if you take the song and put it up on YouTube or something like that, that public expression of that is publishing the song. So basically that gives you a copyright. However, you do need to register your copyrights.
Okay. And I guess is it pretty widespread that when you go into the music industry, a songwriter, you need to be doing this? I mean, there's education.
Oh yes, the education unfortunately comes after the fact most of the time. You start out writing and you just put stuff out there, and then out of the blue somebody records something, and then you start realizing, hey, I'm supposed to get money, right? How do I do that? I mean, I didn't know anything about performance rights. I knew nothing about sheet music, grand rights, like 6 rights or something, until I started getting stuff recorded. And it's really, because copyright has evolved with technology over the years, it's become more and more complex, so it's hard to do the education. The Songwriters Guild has a foundation that does that. Other songwriting groups have a foundation that, the Copyright Office does it. So we get the word out as much as we can. But, most of these writers start out writing when they're 16, 17 years old, and they have other interest in life than reading the Copyright Act.
Right. Okay, thank you. And Ms. Fallon, you had mentioned that CureMark, you had foreign patents. How difficult was it to navigate that process?
Thank you for that question. It's very difficult because in some places you have to have them translated. You have to have the references translated that are cited against you during the prosecution. So it can be a very, very costly process to have them in multiple countries.
And how did you know where to go to begin the process? Who to go to?
Well, our patent attorneys are very skilled in having colleagues in different locales across the world, and so we utilize their services. And we also looked at at areas where we felt that we could get protection, that the protection would be valid and hold.
Right. Thank you so much. Thank all of you for taking the time. I yield back, Mr. Chairman.
Thank you very much. Gentleman yields back. The gentleman from Florida, Mr. Lawson, who's a ranking member of Subcommittee on Health and Technology, is recognized for 5 minutes.
Thank you, Mr. Chairman, and welcome to the committee. And I was just sitting there thinking about intellectual properties, and especially when you say you can get patent across the world. That must be quite expensive to be able to do that. And from the songwriting standpoint, I got a couple of songs, but nobody really want them, you know. But so get a little bit to the point now. I introduced H.R. 2702, which Commercialization Assistance Act of 2017. This bill promotes the third phase of the program that allows startups to engage in federal research and development. How can, and listen to you all this morning, can the federal government, particularly SBA, better promote IP rights with regards to small firms? It's a question for everybody there, because I think that's where it really comes to the heart of everything. Ms. Fallon?
I think that having access to information, as Ms. Rosen said, is very important, and understanding that patent protection is really key to sort of protecting your ideas and being able to go further in your development. And I think that a lot of startups, because I do a lot of advising of startups, and they don't always, it's the thing that gets put on the back burner because it's so expensive. And it's sort of an unknown in some cases to the entrepreneurs. So I think that having education, having access to lawyers, maybe pro bono lawyers who could help with that process would be enormously helpful. I had a brother who had been through it all, and so he was enormously helpful to me in understanding and teaching me about the process.
That's great. Anyone else want to respond to it?
Sure, Congressman. Thank you for the question. I think the federal government can actually look to some local governments for initiatives that are addressing these issues. And there's one in New York City, for example, called the Women Entrepreneurs Fund that is really focusing on directing funds and creating programs for women entrepreneurs to address some of the inadequacies that exist. And so, to the extent that the intellectual property system prevents unique challenges to underrepresented groups like women and like minorities, I think that there are a lot of local efforts like those that serve as wonderful models for creating resources, directing funds, creating programs, specifically addressing those groups.
I'm going to try to get in one question. Does the SBA really understand when you are seeking funding in small firms for intellectual things that related to intellectual properties? Do you have much of a problem accessing capital? Anyone care to respond to it? Mr. Graham?
Do you mean specifically as it relates to getting trademarks and patents,
Right.
getting a loan from the
Right.
SBA? In
Are
order?
the SBA pretty reasonable in on that aspect of it?
We've never taken an SBA loan as a corporation, and our franchisees use our own trademark, so that's not something that we would have addressed. In generally speaking, the SBA does give us many of our loans that we get for franchisees to start their own companies, but that doesn't relate to exactly what you're asking. So, and that process is pretty onerous, but still, it has also some great things that they can use their capital as they can spend their capital as they're applying and things like that that are really great for the SBA.
Okay, Mr. Chairman, I yield back.
Did somebody want to answer? Yeah.
Yeah, I was just going to add. So coming from the technology sector, I think that we don't make enough use of the SBA, and I think there's enormous opportunity for the SBA and the technology and startup world to collaborate because, as I mentioned, all startups are small businesses, and they're not really aware of the resources that the federal government already provides. So I hope to see more collaboration along those fronts.
And just for your bag, when early on you talked about internet and all of the aspects of what's going on, how can you control it? These with intellectual properties, by people having so much access to everything you're doing. I mean, I don't understand how you can control it. I really don't.
We had a trademark for our drug name, which we put through the FDA process, and of course, that's not done. That's not given to you or allowed to be used by FDA until after the drug is approved. But it goes through the process. We had a full trademark on it, and someone just put it up on the internet for something on eBay or on Amazon, selling a sleep aid, over-the-counter sleep aid. Once that name is out there associated with anything, nutraceutical, pharmaceutical, et cetera, it denied us of our name. And we had no recourse.
Well,
Thank you very much.
you're back, Mr. Chairman.
Thank you, gentleman's time has expired. The gentleman from New York, Mr. Espaillat, is recognized for 5 minutes.
Thank you, Mr. Chairman. Good morning, and I want to thank Chairman Chabot and Ranking Member Velasquez for holding this very important hearing on the connection between intellectual property and small businesses. Intellectual property is the result of hard work and innovation that drives around many small businesses. It is ideas that transform and streamline information, connectivity, life-saving medicine, and health intervention, and in many cases are part of a chain of continuum that relies on small businesses to drive and create products that we can all rely on. Protection from bad actors seeking to take advantage of small business products is harmful to their success and longevity. I am glad that we're having this hearing to explore some of these particular issues. Dr. Fallon, my congressional district has a large number of recipients, both for public and private grant monies through federal agencies like FDA, CDC, and NIH for biomedical research and development. We have some of the finest medical institutions, New York Presbyterian Hospital, Mount Sinai Hospital, Montefiore, and other hospitals, and some of the finest academic institutions, Columbia University, Yeshiva University, City College, etc. So it's a hub for research, and in addition to that, we also have the Audubon Biomedical Science and Technology Park, which is an incubator for startups and emerging companies that do research. So I'm concerned. I also sit on Foreign Affairs, and I'm concerned about the predatory practices of even rogue countries that are out there violating intellectual property rights, and even our own country is concerned about that. So how can we protect small businesses from these predators when we are even concerned about countries like China violating rampantly, the intellectual property rights of our companies and other companies across the world? How can we then protect small businesses from this kind of predatory practice where they, at any moment, one of these incubators that we have in the Audubon Park could be subject to a violation of their intellectual property rights? What measures could be taken? If we can't handle this at the broader level, how can we protect small businesses down on the ground in each and every one of our districts?
And it's a very good question. Thank you, Congressman. I don't know the answer. I think that it's an answer that we all search for. I know for us, we have been very quiet about what we're doing and not done a lot of external talking about it, only because then it attracts attention so that people will be looking at that. And I think that it's something that we live with every day, concerned about whether that's going to come into our realm. So I don't really have an answer for you, except to say that I think that things like the American Invents Act and the Track 1 applications, where you get protection right away in a year, that's really helpful instead of having it wait a couple of years going through the process, so you know whether you have a patent or not. And I think those kinds of things are really important for companies like mine.
I don't know if any of the other panelists would like to weigh in.
I would love to speak to that. So I think when you're talking about foreign threats to intellectual property, certainly efforts like the TPP, which attempted to address these issues specifically in Asia, you know, not everything in the TPP was perfect for sure, but to tackle those issues and to sit down with the countries where this intellectual property infringement is happening and try to work out the starts of a solution, I think is one good way to address these. And I would just add that the importance of protecting the reforms that have already taken place here within the United States and making sure that the Supreme Court decisions, that Section 101, that the post-grant review process, and the America Invents Act are all protected. I know that Congressman Evans mentioned the Stronger Act. That bill would roll back a number of those protections and leave small businesses and startups vulnerable again, as vulnerable as they used to be. So shoring things up at home is really important as well. Thank you.
I would like to just add, no intellectual property has been more threatened over the last 20 years, particularly by the internet, than music and movies. And what we learned in this process has been very valuable. You have to start off with a safe legal alternative that's easily accessible. You have to have education, and then you have to have an effective deterrent to the crime. So if you can get those three things in place, you can have some control, even in an environment where rampant copying is in place.
Thank you, Mr. Chairman, for extending additional time.
Absolutely. The gentleman's time has expired, and we want to thank the panel for being here today. I think all the members that had questions on both sides got to ask them. And whether it's patents or trademarks or copyright or trade secrets, all of these protections are vital to helping our innovative small business owners thrive and grow our nation's economy. And I'd like to thank our four very distinguished witnesses here this morning and now into this afternoon for shedding some light on how this committee can play a role in strengthening those protections and assisting small businesses all across this country. So thank you very much for that. I would ask unanimous consent that members have 5 legislative days to submit statements and supporting materials for the record. Without objection, so ordered. And if there's no further business to come before the committee, we're adjourned. Thank you very much.